enforceable penalty. And in order to do that, you need to look at the detailed financials on the transaction. We haven't exchanged that discovery, and we haven't done our 30B6 depositions yet. We need that to happen before we're going to be ready for trial. And so that was why we were asking for the continuance. We may need some expert opinion testimony for you as well, Your Honor. I expect that we'll need that. So until we have that discovery, the case isn't going to be in a position to go to trial.
Response.
Your Honor, we agree with that. We're also intending to file a motion for summary judgment, which may eliminate the need for a bench trial, depending on how Your Honor rules, if there's fact issues or not. So there's still some work to be done in this case. We had originally agreed to an October deadline, and plaintiff wanted to move that, and Mr. Dunwoody is correct, we had agreed with that extension. So at a minimum, I think we need at least a few months to get that discovery completed and get the motion papers in front of you.
So tell me exactly, you need how many depositions?
I think one for our side, Your Honor.
And then how many, what discovery, written discovery has that already been sent and not responded to, or?
Yes, Your Honor.
Continuance or compel?
Your Honor, we've responded, but we had to redact it until a protective order was entered. And I understand that there's now been a protective order entered, so we'll be serving the unredacted responses to the discovery.
And that's all the discovery that needs, that written discovery that needs to occur?
We need to evaluate what we receive, Your Honor, and see if that's complete. And based on that, then we'll be in a position to do expert reports on the financial issues. And then at that point, we'll know if there's any additional discovery that's required. Right now, that's what we anticipate is they'll give us, the defendant will provide complete financial answers. Our expert will be in a position to offer his opinions. We'll do 30B6 depositions on both sides, any expert depositions that are required, and then we'll be ready for trial.
Could you guys be ready maybe mid-July?
No, Your Honor.
And because it sounds like you just need one deposition.
No, Your Honor. I'm sorry if I wasn't clear. What we need is we need to get discovery from the defendants in this case. We need a chance to look at it, get that information to our experts. We need to take a 30B6 deposition on the other side. We need to issue expert opinions. They may have responsive expert opinions. Expert depositions will need to be completed, and then the case will be ready for trial. And so that's, in my experience, that's on a fast pace would be a 90-day process, and it could take longer than that, depending on whether or not there's additional discovery that needs to be secured on the front end before the experts are ready to issue their opinions.
What is your expert designation deadlines? Are those not passed already?
We have designated experts, but it's pending supplementation because we did not receive the full and complete responses to the discovery. We've been trying to hold off on having a discovery fight. They've agreed to provide the information once a protective order was entered, Your Honor, but we were waiting on the protective order to be entered.
I really think you could get this done quicker than 90 days. All right, I'm going to go ahead and reset it to the second Tuesday in August.
Okay, I know that we have a conflict then, Your Honor. I don't have a vacation letter on file, but.
What's your conflict?
So two conflicts. One, I'm supposed to be out of town at a wedding in Mexico.
On the 11th?
Yes, Your Honor.
Okay.
That week through the 16th, which I believe is a Sunday.
Okay. Let's go ahead and set it then on the 4th
of August.
Yeah.
And Your Honor, if you would, what's your process then for a bench trial where you're going to be receiving, I would expect, probably 4 witnesses. I don't think they would take a long time to testify, but is that something where you'd start at 8 a.m. and just try to knock it out in one day, or?
Yeah, it depends. We start at 9, and I presume right now the instructions we have from the Office Court Administration is to try to do as much as possible remotely, which is what we're doing. By August 4th, I assume that will still be the case, but I don't know. So, but assuming it's on Zoom, pursuant to our the district judge's emergency order, you would need to get my court reporter and court coordinator any exhibits that you need to be shown, so that they make sure they have a copy of that in advance of the trial. We allow you to use the share screen function of Zoom, assuming that it is remotely. Then we just try to, if we can get it done in a day, great. If it goes into a second day, we can do that too.
Yes, Your Honor. So you've set us for August 4th.
August 4th. Guys, anything else? I'm not trying to give you a hard time. I'm just trying to balance all the different issues that are going to come up as the year goes on.
Yes, Your Honor. I mean, I think we were clear where we said we didn't think that's enough time, but obviously we'll do our best and we'll come back to you if it becomes an issue.
I would just say that you need to aggressively pursue the case at this point.
Understood, Your Honor.
And Your Honor, if we wanted to file a motion for summary judgment, I assume that would also be a Zoom hearing?
Yes, I presume, unless, there's a vaccine or the rules change, but my guess is that most hearings through June and July are going to be via Zoom, and bench trials. August, I just don't know. And then jury trials are may start as early as August, but they may not start until September or October.
Yes, Your Honor. Good to see you. Thank you for your
All right,
time
guys.
this morning.
Thank you, Your Honor.
And Rhonda, make sure you set that, okay? Thank you. You guys be safe out there, okay?
Thank you.
Thanks.
Is anyone here on the Wildwood Natural Corporation versus Shin-Chan Market case?
Yes, Your Honor. Plaintiff's counsel's here.
And defense counsel, are you here?
I see him here on mute.
Mr. Rowland, you need to unmute, sir. Unmute.
Mute.
There we go.
All right, Your Honor.
That's great. That's great. So you guys are here. Do you guys want a record? We have 2 motions to quash. Is that correct?
Yes, sir.
All right. Tony, ready? Tony, you there?
Yes, I'm here. I'm ready.
Okay. Let's go on the record, and we are on YouTube. Cause number DC 1916287, Wildwood Natural Corporation versus Shin-Chan Market. Counsel, make your appearances.
Good morning, Your Honor. Papul Chaudhary for plaintiffs Wildwood Natural Corporation and Chansho Park.
Good morning, Your Honor. This is Daniel Rowland, and we are on behalf of defendants Shin-Chan Market and Ki P Na.
Let's go ahead and proceed.
Your Honor,
Your Honor.
2 motions before the court, plaintiff's motion and defendant's motion.
Your Honor, we set the motion. If you wouldn't mind us going first, that'd be great. We'd really appreciate that.
They set our motion first. They set our motion to be heard first, so I think that we should be able to proceed first.
Which motion was filed first?
The plaintiff's motion, Your Honor.
Plaintiff goes first then.
Thank you, Your Honor. Your Honor, regarding the deposition of my client, Chansho Park, the parties agreed that the deposition would proceed on June 3rd, which is this Wednesday. Now, despite multiple requests from myself to have the deposition occur via Zoom, the defendants have insisted and noticed the deposition to occur at our office. My client is 65 years old, which makes him high risk, and I personally have a health condition which would mean elevated complications if I were to contract COVID-19. Now, over the weekend, it was announced that the total number of COVID-19 cases in Dallas County has risen to over 10,000. My client and I shouldn't have to risk death over a deposition. It can be done remotely. I've defended other depositions in the past few months via Zoom, including 2 with Korean translators, and they've worked out just fine. I think it goes without saying, but this very hearing here is occurring via Zoom. The court isn't allowing anyone to appear in person yet. The defendant should not be permitted to force my client and I to risk our health for a deposition when the court itself is not permitting anyone to appear for anything. Our position is that what the real story here is that this case was filed in October 2019, and the defendants did nothing to defend the case until May. And now with the trial date rapidly approaching, they're trying to do whatever they can to push out the trial date. A few weeks ago, the defendants had filed a request for a jury trial. Now the rule is that the request must be filed in a reasonable time, no later than 30 days before trial. But we would submit that filing a jury trial request in late May on a case filed in October 2019 is not filed in a reasonable time. Moreover, last week, the defendants have now filed an opposed motion for continuance to push the trial out to February 2021. Thus, the defendant's insistence on an in-person deposition is really just an attempt here by defendants to force the court to push out the trial date. Nevertheless, the bottom line here is that there is no good reason that this deposition cannot go forward this Wednesday via Zoom, so that no one has to risk their health by traveling to an office and doing a deposition that people every day in this pandemic are doing remotely, even with Korean translators. And with that, I'd like to reserve the bulk of my time, the remainder of my time, for a brief rebuttal.
Okay. Mr. Rowland, I think he's right, but let me hear what you have to say.
Thank you, Your Honor. I think first of all, we have to talk about what the facts of this case are and why we are asking for an in-person deposition. This is a forgery and fraud case, and we're talking about handwritten Korean notes, promissory notes. I think there's a series of 4 for about $450,000. We're saying, and we have good evidence of, we don't want to give this all the way now before our deposition, of significant forgery concerning both signatures and dates. Now, what we really need to do is go over these documents in person with markings and go over and ask the person about basically lies and forgery regarding how they've changed these documents after we signed them. And we have good reason for that. So that's one of the reasons why we need to depose this. And one of the things that we're talking about here is that the plaintiff that we're trying to depose, the plaintiff is the sole individual plaintiff in the case at bar. The entire testimony revolves around this plaintiff, and it's extremely critical testimony. Courts hold that when testimony is critical, forcing people to do remote depositions would be unduly prejudicial. And the reason is we have so many documents to go over that are in handwritten Korean that we have to point to and actually do in person. I mean, we all know that in-person depositions can be beneficial when you're trying to get someone to be more truthful than they might otherwise be when you're talking about fraud. We're not even talking about that. We're talking about pointing to tons of documents, because a lot of these are now bank checks too that have been sent back. So we're going over tons of bank checks and tons of handwritten Korean promissory notes containing forgery and fraud. And so we understood, we waited. The reason, I think we're saying that the plaintiffs are trying to have it both ways. They're trying to prosecute their claim during COVID, not wanting to continue the case, while simultaneously trying to impede our right to defend the case. So we're thinking they're using COVID as kind of a procedural weapon. And that's why we've offered what we think is a very, very reasonable solution to this, which was we think we need to properly defend the case, do in-person depositions. We waited until orders, government orders, Abbott's orders would allow for that, in which case we then filed it. They said, you know, we are still concerned about our safety. And so we said, okay, that's fine. Why don't we just continue these dates until we can prosecute this claim and defend this claim at the same time, that you can have your safety and we can properly defend our case. They said no. They want to have it both ways. They want to be able to prosecute their claim while not allowing us to properly defend against their claim, while simultaneously claiming COVID whenever they want it, but while still forcing us to go through this entire thing during the pandemic. So we don't think they can have it both ways, Your Honor.
Mr. Rowland, I'm sure you've seen the most recent Supreme Court order, as well as the emergency order of the Dallas Court of Appeal, Dallas Civil District Judges. Your motion to quash is denied. All right, so what's the other motion to quash?
Your Honor, that's my motion to quash, Your Honor.
Your motion to quash.
Yeah,
Oh.
we filed a motion to quash their
Sorry.
deposition notice and asked that it be ordered that they proceed.
It will be, okay, the order, I'm sorry, I misunderstood the procedural context. So your motion to quash the deposition taking place in person is granted. It will be ordered to be conducted remotely.
Your Honor, in that case, can we briefly discuss our motion for continuance? We really do believe that, I mean, we have a jury trial, like the other side said. We know, we've seen your Facebook post about jury trials not happening, at least until August 1st. Currently, our jury trial or non-jury trial was scheduled for the 21st. Like you said, we've put a jury trial demand in. We've paid our fee. So we know it can't happen, at least when it's scheduled to happen for a jury trial. It seems like we're arguing to a certain extent over moot points because we know we can't have the jury trial until after August 1st. Why can't we just push back this continuance or do the continuance, and this kind of will all be a moot point if we can actually get this continuance, which has to happen because of the jury trial.
Can I
I'm not
respond to
sure.
that, Your Honor?
I'm sorry, I'm not sure I'm following you. What being a moot point about doing the deposition? The deposition is going to go forward remotely. So that issue is decided. The issue of whether or not the trial setting will take place on July 23rd, I agree with you. It's not going to take place on July 23rd. I would prefer to decide the motion for continuance closer to trials. And the reason for that is just, I don't know when we're going to be having jury trials. It could be in August, it could be in September, it could be in October. We just don't know. It could be later. It's still up in the air. So I would suggest we just make that decision a little bit later and not decide it now when we have such imperfect information. But I agree, it won't go forward on July.
Well, so to tag along with that, I think my point with that, Your Honor, was if that's the case, which I think we both agree, would it be possible to leave the door open on this deposition merely because we're talking about a Korean interpreter trying to ask about handwritten Korean notes in person? It's just going to be very, I mean, the cases talk about being unduly prejudicial of critical witnesses in which there's document intensive. We just really feel like it's going to be important to properly defend ourselves in this suit, to be able to in person
Respectfully,
talk to this
Mr. Rowland,
fraud claim.
Mr. Rowland, I've already ruled on this.
Okay,
So I'm really trying to be patient with you here on
okay, I'm
this.
sorry, Your Honor.
But at a certain point, I don't want, the interns have not seen me and Judge Hoffman yet. I don't really want to bring him out right now, but I've ruled on this. And so please respect the ruling, and you're going to need to go forward with the deposition remotely. So,
All right, thank you.
And about the continuance, I am going to continue it. I would just say, let's get closer to the date. I'm sorry, I don't know how to say your name, Mr. Chaudhary.
Notary?
Mr. Chaudhary, I've always interpreted that rule as long as he pays the jury fee at least 30 days in advance, and he should be able to get a jury. So it's gonna be a jury trial and it will be continued. I'd rather decide that issue later when we have a better feel for what kind of what's going on.
Understood, Your Honor.
Can you guys
Thank you,
hear
Your
me?
Honor.
All right, anything else, guys?
There's a defendant has a motion that's
Okay.
on the table right now.
What is your motion?
Your Honor, we withdraw our motion to quash, considering your ruling earlier. Our motion to quash it will not be necessary, and we're withdrawing it.
Okay. Anything else, guys?
That's it. Your
That's
Honor.
everything.
All right, you guys be safe out there. Good luck, and we'll go ahead and have you set your motion for continuance yet?
We called this morning, Your Honor, to the court, but I think because of the riots, they said that the courts were having a little bit of issues. And so
Yeah,
we're having,
the courthouse is closed, so.
right.
Rhonda, why don't we set his motion for continuance, maybe at the beginning of July? And hopefully we'll have a better feel for then kind of when we'll actually be trying jury trials. So maybe the second Monday in July. That work for you guys for the continuance hearing?
Yes, Your Honor.
So I don't know if you guys are local or not. Looks like you're local. So you want to shoot for like 10 o'clock?
That works for us, Your Honor.
That works, Your Honor.
Okay, guys, you be safe out there, and we'll go ahead. Just give me an order. Have you already sent an order in on this?
For the motion to quash, Your Honor?
Yeah.
Yes, we have this morning, Your Honor.
Can you modify it based on what I said today, and then email it to opposing counsel and email it to my court coordinator?
I think the order conforms with your ruling, Your Honor.
Does it already? Okay, let me see if I have that. Give me 1 second.
Your Honor, I think the order says that we have to take the deposition at that time. So I don't think that it completely conforms with the your order.
Well, no, that is accurate. It does need to take place at that time. Let me see. What day did you file this particular motion to quash?
It was filed May 20th, Your Honor.
Let's see, and that's when the order was filed?
No, the order was filed this morning.
Okay, let me see. Yeah, just to make it easier, go ahead and email my court coordinator. It isn't on the system yet, and it may not be on the system for a few days. So go ahead and email my court coordinator the order.
Okay.
And good luck with the deposition.
Thank you, Your Honor.
Right.
I thank you
Thank you, Your
guys. All right, and interns, why don't you guys stay? And counsel, you guys be safe out there, okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Okay, and Tony, our next hearing is at,
At 1:30.
yes, at 1:30, and then, which probably is not going to need it probably will not need a court reporter. That first one won't. And then our temporary injunction at 4 o'clock in the HC legal is canceled. But there's another 4 o'clock on the Clark Ridge Canyon case. Oh, shoot, I'm still on Zoom.
I'm still here.